Benjamin Franklin wrote under the pseudonym of Silence Dogood in April 16, 1722, quote, I am an enemy to vice and a friend to virtue. I am one of an extensive charity and a great forgiver of private injuries, a hearty lover of the clergy and all good men, and a mortal enemy to arbitrary government and unlimited power. I am naturally very jealous for the rights and liberties of my country, and the least appearance of an encroachment on those invaluable privileges is apt to make my blood boil exceedingly. End quote. In the 1215 version of Magna Carta, King John acknowledged, quote, we have granted moreover to all free men of our kingdom all the liberties below, end quote. Quote, free men, end quote, were the knights, barons, and small class of free tenants of land, not the large majority of the population who were villains or other serfs. There follows a long list of such concessions, some profound, others whose inclusion must have been due to some alarming event or some quirk of history or contemporary custom or feudal practice. Whatever the reason, even fundamental matters such as that no tax shall be imposed except by the common council of the kingdom, or that criminal convictions, at least for nobles and freemen, must be through trial before a jury of peers, were cast as matters of the king's grace. Perhaps that formulation was due to the fact that the barons were holding King John hostage until he agreed to the terms, and those barons wished to make the matter look like a voluntary arrangement. But what the king grants, the king can take away, which John promptly did by repudiating the charter once it was released. By the time of the American drive for independence, the original Magna Carta had little legal effect in England, with only a few provisions remaining in force after the subsequent issuance of differing versions and the enactment of various English statutes that overrode most of those provisions. However, Magna Carta retained a mythical hold on Americans who argued that they were not rebelling against their constitutional government, but preserving their ancient rights as Englishmen against usurpations by the king and parliament. Americans believed the Whig perspective that Magna Carta protected the right of common Englishmen against arbitrary royal government and placed the king under the ancient common law. The jurist Sir Edward Coke had been the most influential originator of this idealized interpretation during his political clashes with the Stuart kings early in the 17th century. Not everyone agreed, but certainly not James I and Charles I. A bill introduced in Parliament in 1621 to confirm Magna Carta as law failed. Appealing as Magna Carta was symbolically as a written constitution that represented a contract between king and people, when Americans actually read it, they could not avoid the fact that the language of the charter assumed that the rights involved originally belonged to the king. Moreover, the king had granted the enumerated rights only to a select few. This stood in clear contrast to the dominant theory at the time of the American Revolution, that every person is endowed by God with certain rights. Those were inherent in such persons by the grace of God, not by that of the king. The theory of universal natural rights inherent in each person was a distinct derivative of the much older theory of human law and relations controlled by universal higher moral laws or by principles of natural justice. It was distinct because it focused on the sovereignty of each person, independent of all others, and connected to the exercise of the person's own rational self-interest. It placed the individual at the center of social community and required, at least as a general theory, the consent of each to form a political commonwealth. Duties undertaken to others arose out of the free exercise of one's right to consent to do so. The more traditional approach of writers on natural law and natural justice had assumed the operation of a universal order external and antecedent to human society. It functioned concretely, as manifested in the physical universe and human society, and morally through human reason. Each person was a part of both aspects of that order. Moral and, ultimately, legal duties to others could arise only in humans as creatures who have the capacity to participate in the moral structure of that order. From these natural duties arose rights to make it possible to meet those obligations. In Nicomachean Ethics, Aristotle distinguished between natural and conventional justice. Quote, political justice is of two kinds, one natural, the other conventional. A rule of justice is natural, that has the same validity everywhere, and does not depend on our accepting it or not. In a similar manner, the Roman philosopher and political leader Cicero, expressing a Stoic interpretation, repeatedly explored the connection among law, justice, nature, God, and reason. Just a few select passages from his book, Laws, suffice as examples. Quote, law is the highest reason implanted in nature, which commands what ought to be done and forbids the opposite. But in determining what justice is, let us begin with the supreme law, which had its origin ages before any written law existed or any state had been established. End quote. Once it was established that there were a superintending structure of natural law, commensurate in its essence with reason, Cicero explained how humans can participate in that order and can understand the duties created thereunder and exercise the correlative rights. Quote, that animal which we call man, endowed with foresight and quick intelligence, complex, keen, possessing memory, full of reason and prudence, has been given a certain distinguished status by the supreme God who created him. For he is the only one among so many different kinds and varieties of living beings who has a share in reason and thought, while all the rest are deprived of it. End quote. Such a momentous project is the work of an all-powerful and all-knowing superhuman mind. Quote, natural law is not a product of human thought, nor is it any enactment of peoples, but something eternal which rules the whole universe by its wisdom in command and prohibition. Thus, they have been accustomed to say that law is the primal and ultimate mind of God, whose reason directs all things. End quote. Finally, a human enactment, no matter the political system which created it, cannot truly be law if it conflicts with the higher natural law. Quote, neither in a nation can a statute of any sort be called a law, even though the nation, in spite of its being a ruinous regulation, has accepted it. Therefore, law is the distinction between things just and unjust, made in agreement with that primal and most ancient of all things, nature. And in conformity to nature's standard are framed those human laws which inflict punishment upon the wicked but defend and protect the good. End quote. Cicero had not been alone in distinguishing between a statute which is not truly law and one which is, because of its conformance to justice represented by higher law. The distinction was clearly expressed by, among others, justices of the early Supreme Court. For example, in a colloquy between himself and Justice James Iredell, Justice Samuel Chase declared in 1798 in Calder versus Bull, quote, an act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority, end quote. The, quote, first principles, end quote, to which Chase referred are those of natural law and natural rights, as shown by Iredell's skeptical response. Quote, it is true that some speculative jurists have held that a legislative act against natural justice must in itself be void, But I cannot think that under such a government any court of justice would possess a power to declare it so. The ideas of natural justice are regulated by no fixed standard. The ablest and the purest men have differed among the subject, and all that the court could properly say in such an event would be that the legislature, possessed of an equal right of opinion, had passed an act which, in the opinion of the judges, was inconsistent with the abstract principles of natural justice. End quote. St. Paul acknowledged the universality of natural law and its connection to the God of all mankind. In his letter to the Romans, Paul explained that, quote, when Gentiles who do not possess the law do instinctively what the law requires, end quote, it proves that God's universal law exists outside any particular received commands. Those Gentiles, quote, show that what the law requires is written on their hearts, to which their own conscience also bears witness, and their conflicting thoughts will accuse or perhaps excuse them, end quote, on the day of judgment. In that manner, enlightened pagans such as Plato, Aristotle, and Cicero might have keen insight into the moral order created by God, and they would be judged the same as those who had received the declared law. They were accountable for their thoughts, words, and deeds under the natural moral law, although their ignorance of specific aspects of the declared law might not be held against them. Then why was it necessary to have revealed law at all? Philosophers and theologians have long made it clear that not all people possess equal capacity to understand what God has written on their hearts, but also that the reason of all humans is imperfect due to the human condition. Humans lack the omniscience of God and his perfect reason to comprehend the full extent of the natural law. Revelation is necessary both for those matters whose substance is beyond human understanding and, at least for some people, quote, about those religious and moral truths which of themselves are not beyond the grasp of human reason, end quote, in the words of Thomas Aquinas. Alexander Hamilton, in his essay number 33, and James Madison, in essay number 44 of the Federalist, made similar arguments about a rather different matter. In Article 1, Section 8, the Constitution expressly grants Congress the power to legislate regarding certain substantive matters. The question presented was why the Constitution also gave Congress the power to make all laws, quote, necessary and proper, end quote, to carry into effect its other powers, when Congress already had the implied power to make such laws as a means of effectuating the ends specified in the Constitution. As Madison pointed out, quote, had the Constitution been silent on this head, there can be no doubt that all the particular powers requisite as means of executing the general powers would have resulted to the government by unavoidable implication. No axiom is more clearly established in law or in reason than that wherever the end is required, the means are authorized. Wherever a general power to do a thing is given, every particular power necessary for doing it is included, end quote. Hamilton concluded that, quote, it could only have been done for greater caution and to guard against all caviling refinements and those who might hereafter feel a disposition to curtail and evade the legitimate authorities of the Union, end quote. In other words, the implied power to make such laws already existed under universally accepted and applicable principles of government. But the extent of implied powers is ill-defined and subject to considerable debate and uncertainty. The express enumeration, then, provides a more concrete statement less subject to manipulation and deception. If the immutable laws of nature represent the work of the divine reason, good human laws are the result of human reason applied to concrete conditions and problems. But human laws are sometimes the product of passion, often temporary, rather than of reason, in denigration of the classic definition. Hamilton expressed this problem in essay number 78 of the Federalist, where he characterized judicial review of legislation as itself an act of reason to control the ill effects of popular passions. Quote, "This independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors which the arts of designing men, or the influence of particular conjunctures, sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government and serious oppressions of the minor party of the community." End quote. As Cicero taught earlier, the fact that these laws, enacted as the result of temporary public passions, may have been approved by the nation, does not lessen their incompatibility with the Constitution and with reason. Mob rule would be another, perhaps even more blatant, triumph of passion over reason than the arbitrary human law hastily produced by the legislature. That body had more of an opportunity to calm those passions, or might at least blunt their force in the eventual statute. However, there is another side to be considered. What is mob rule? Does the uncoordinated, broad refusal of the people to go along with an arbitrary statute qualify as such in what has been dubbed, quote, Irish democracy, end quote? Is direct peaceful opposition by large numbers in the form of demonstrations and petitions? Is rioting and violent opposition? Is insurrection by destroying government property, tarring and feathering government officials, and shooting at soldiers? Or is even the last of legitimate form of opposition to allegedly arbitrary government, at least if those opponents eventually win and write the history books? After all, to the British and in the 1760s and 1770s, Americans often engage in mob rule by a violent minority of faction, which then escalated to insurrection and eventually full rebellion in a civil war. The Constitution is positive law proposed by humans in Philadelphia and approved by assemblies of humans in the several states. The Charter incorporates what the Supreme Court has accepted as universal principles of natural law, such as prohibitions of ex post facto laws or of laws which interfere retroactively with the obligations and rights in contracts, take property without compensation, or as mere redistribution for a private person's benefit, deny basic protection of due process, burden one's self of self-defense, or interfere with fundamental rights of conscience by abridging rights of free speech, assembly, press, and religion. If Thomas Paine is correct, and there is a natural right of self-government, the Constitution even protects that right, at least within broad bounds. Still, even the Constitution is not at one with the immutable, constant laws of nature. What the human lawgiver gives, it can take away, just as King John did with Magna Carta. The Constitution can be amended, and nothing in its text prevents the nullification of the rights mentioned earlier. Nor is the discovery by the Supreme Court of enumerated rights through flexible and creative interpretation of liberty under the due process clauses of the Constitution inherently immutable. Such discoveries can be reversed or neutralized by the Supreme Court itself, as happened recently with the retraction of the right of a woman to obtain an abortion, first discovered rather belatedly in 1973. Or a formal amendment can be adopted which overrides an earlier Supreme Court opinion, as has happened several times. Nor does the Constitution address all principles of natural law and natural rights. It was not until adoption of the 13th Amendment in 1865 that the Constitution took a clear position against slavery, Although Western philosophers of ethics and politics and theologians had wrestled with that issue for millennia and had found slavery to be contrary to nature and natural law, at least under many circumstances. Worse, the Constitution itself may conflict with a natural law and natural rights. After all, a mere 5 years earlier, on the eve of Civil War, President Abraham Lincoln and other Northern politicians had advocated for another far different 13th Amendment, one that would have expressly protected at the level of constitutional law that very same institution of slavery in the states where it existed. Only the refusal of Southern radicals to accept the geographical limitation in that proposal and the force of the process already set in motion in the Southern states towards secession prevented its further consideration by Congress. Another difficulty lies in this. To the extent that the Constitution's text falls short of manifesting the immutable, constant laws of nature and the extent of natural rights, may the Supreme Court fill in those gaps? The Ninth Amendment does no more than state the obvious, that the enumeration of certain rights in the Constitution does not exhaust the scope of rights each person has. It provides no express license for the Supreme Court to substitute its judgment for that of the people or the people's representatives. Moreover, as Justice Iredell objected in Calder, the commands of the natural law and natural justice are difficult to discern, especially in application to specific and varied circumstances, and have long been the object of philosophic speculation. Of course, the people, or their representatives, should make law only in accordance with natural law. But the problem is precisely that they often are driven by self-interest and passion, not by the requisite reason. Nor are the people generally, or the legislators, inherently qualified as moral philosophers any more than the judges. This quandary requires inquiry into the role of private and public virtue in the promotion of proper self-government and the establishment of a political order and human law consistent with the natural law and the protection of each person's natural rights. Joerg W. Knipprath is an expert on constitutional law and member of the Southwestern Law School faculty, and he is a Constituting America Fellow. This essay was written, obviously, by Joerg Knipprath, and it is entitled Principle of Law and Order Based on Immutable Laws of Nature and of Nature's God, Not Arbitrary Will of Any Ruler or Mob Rule. We thank you for joining us today for our 13th annual 90-day study. I am Janine Turner, founder of Constituting America, and I and Kathy Gillespie, Constituting America's CEO, welcome you to this study. It's actually entitled 90 plus 90 equals 180. History holds the key to the future. That is our annual study. This is our 13th such study, the first principles of the American founding. Please spread the word to friends and family on social media, text, phone calls, emails, however you communicate. And don't forget to check out last year's study on American exceptionalism. It walks through 90 essays, giving us the tools to understand why America is exceptional, and thus the ability to explain it to someone else when they doubt America. Perhaps they doubt America is exceptional. Is exceptional. Have a wonderful day. We thank you for joining us, and we'll meet you right back here tomorrow.